The story goes like this. A woman had 3 children, and these were children that she had out of wedlock. And these children were under the care of the aunt of the mother since their birth. So let's call these children K, P, and W. For this particular situation, the aunt or the children's grand-aunt was providing caregiving for them. Now, this woman subsequently married a man, and she had 3 children with her new husband. She was absent from the lives of K, P, and W since their births. What is perhaps quite significant about this particular relationship was that on one occasion, P, one of the children, needed an operation for respiratory problems, and the aunt was not able to contact the mother directly. Instead, what she had to do was to go to KK Hospital's medical social worker in order to get the mother's consent for that particular operation. And so subsequently, this grand-aunt applied to court to be appointed as a guardian of the children. And what happened was that the court said, well, looks like in this particular situation, your mother, talking about the children's mother, is not apparently going to take responsibility over her children. And in that particular situation, the court also looked at the grand-aunt's caregiving over the children and said that, look, you seem like the proper person to be appointed as the guardian of the children. And so the court granted her application to be appointed as the guardian of the children, and also ordered the mother to pay maintenance for the children. In other words, to pay money for the support. In other countries, this can be called child support. So, what is this? This is actually a real case that came before Singapore courts, and it does highlight some of the challenges and difficulties that when we talk about parents and children, and in terms of parental rights and responsibilities, we do encounter some gaps because there are indeed parents out there for various kinds of reasons, may not want, may not be interested, may not actually exercise that kind of responsibility over the children. So what I'm going to talk to us today is the idea of guardianship. Now, guardianship is a legal status under the law, and it gives a person responsibility, legally, to care for a child below 21 years of age. And so, why do we have this system of guardianship? Because the law draws quite a strict distinction between parents and non-parents. For parents, there is a natural authority, natural responsibility in relation to children. But for a non-parent, legally speaking, typically there is no relationship to children at all. And because of this sharp distinction, we run into some of the challenges and some of the questions that we have faced in this particular case I've highlighted. So this was a quote from a particular working group back in 2016, and they were reviewing guardianship laws in Singapore, and they said this: parental authority arises naturally. It is not the law that bestows authority on a parent. The law merely acknowledges that a parent naturally has authority. Good law seeks to protect parental authority and regulate it in an appropriate way. Now, in terms of our legal framework, a guardian typically has almost the same responsibilities as a parent, with some key exceptions. First, a guardian, as we have seen from the case highlighted above, is not obliged to maintain a child, meaning that the guardian doesn't actually have to pay for, let's say, the child's upbringing and so on and so forth. Instead, the law regulates in a slightly different way. If a guardian doesn't provide all these things, then there may be certain kinds of criminal obligations that follow. Now, when it comes to the role of a guardian can also be limited in his or her role and powers in relation to the appointment over the child. So, for example, a guardianship can be said to be, okay, you're only allowed to deal with this particular set of issues. Or, for example, it can only be for a limited time only, failing which, it will revert to someone else, or it will terminate, and so on and so forth. So, how is a guardian appointed under Singapore law? 3 ways. First is when a parent passes away, so the surviving parent will become automatically the guardian of the child, or the parent who passes away can actually write a deed or a will to appoint someone as the guardian if and when the parent passes away. The second way to do it is by court appointment, and the grounds of it are quite narrow. It says this, where a child has, quote, no parent, no guardian of the person, and no other person having parental rights with respect to him. And the third way is something known as wardship jurisdiction. And this is something a little bit unclear, I think, to most people who are not trained in the law, but it is developed by the courts as a way to protect children. And so the case that we've talked about was indeed one of those cases where the court said that, well, this is not a situation number one, this is not situation number two. Unfortunately, we will have to come up with our own remedy, and this is situation number three. It is a case of wardship jurisdiction. So, the judge who heard that particular case said this: there is a need for, quote, a clearly defined statutory regime through which non-parents may apply for the necessary orders for the welfare of children, and she also called for specific provision for non-parents with some connection to a child to make applications for custody, care, and control and access in appropriate cases. So I go back to this particular working group that I've alluded to earlier. In 2016, a particular working group was convened to review our guardianship laws, and this was comprised of judges, academics, representatives from the government, as well as legal practitioners. And it recommended various kinds of reforms to our Guardianship of Infants Act to, quote, put guardianship in Singapore on a modern platform that emphasizes parental responsibility and the welfare of the child. Cultivate, we are putting forward some recommendations for the reform of guardianship law, and our first recommendation is as what Justice Debbie Ong said. First, to create a clearly defined statutory regime, and second, is to make specific provision for non-parents with some connection to a child to make applications for custody, care, and control and access in appropriate cases. And all of these are illustrated in the case that I highlighted earlier. Now, let's give you another hypothetical scenario. Let's say we have a situation where a widow has two young children, and she receives a diagnosis of a medical condition, and this condition will cause her to become incapacitated. Maybe it's a coma, maybe it's a kind of mental, let's say, incapacity. Maybe she's not able to make certain decisions anymore because she's not conscious. And it will cause her to become incapacitated physically and mentally in approximately 1 year. If we look at the three ways under Singapore law currently, can she appoint a guardian for the children? So if you look at the first ground, when a parent passes away, no, right? She is not passing away. She's becoming incapacitated, so this ground is not allowed. Second, court appointment. Again, this is a situation that only applies if a child has no parent, no guardian of the person, and no other person having parental rights with respect to him. So the only option left is what we've talked about, the wardship jurisdiction, and this one is one where the law is not clearly defined, and the judge herself has called for a reform of the law. But what if we could actually empower her to make decisions now? If we think about something similar under the law that exists already, the lasting power of attorney. And I think we have all seen various kinds of advertisements, sometimes in your HDB blog, sometimes in community clubs, and so on and so forth. These actually tell you that in the event you lose mental capacity, you can appoint somebody to make decisions over your personal affairs, over your finances, and various other kinds of matters, depending on the scope of the lasting power of attorney. So this currently exists under the law with respect to making decisions for you. But what about a situation where it comes to taking care of children? So what if we could allow her to nominate somebody as the guardian in the event that she loses capacity? Second, what if we could enable her to apply to court to appoint somebody as a guardian when there is no one able and willing to discharge parental or guardianship responsibilities? Or what if we could allow someone else to apply to court in that kind of situation? So the second option here is perhaps, why not let's create some additional options to allow for this particular lady to make plans for her children if and when this kind of thing happens to her. So, our second recommendation is to allow for guardianship in the event of inability, not simply a situation where there is no parent around, not simply a situation where a parent passes away, but to allow a parent to nominate a person as a guardian in the event the parent loses capacity and there is no one else able to discharge parental or guardianship responsibilities, and to allow the court to appoint a guardian when there is no one able and willing to discharge parental or guardianship responsibilities. So this is our law reform proposal, and this is currently live on our website. Please feel free to check it out if you'd like to read it in full. And we have sent it in to various government ministries. So if you have any thoughts, comments, or feedback on this particular proposal, please feel free to share it with us. We'll be happy to hear your thoughts. And as we all went through an exercise of thinking about family, thinking about what can we do to change some of the notions, I think fundamentally what we're really concerned about is the welfare of children.